Okay, we are going to be talking about civil liberties today, and civil liberties can be found in the Bill of Rights. The Bill of Rights, of course, look like that, and they're housed pretty close to where you go to school, downtown in DC, and you can go see them. They have them out in public during the day, and they put them underground during the night. In case you hear sounds, today's recording is coming from Apollo Gymnastics in Woodbridge, Virginia, where my daughter is starting her 4 hours of practice this afternoon. She does a lot a week, 17 hours. So if you hear flips and bounces, you know where it's coming from. So first of all, civil liberties are the rights that you have that grow out of the Bill of Rights. Those are the first 10 amendments in the Constitution. And you can't alter them by law, you can't alter them by executive order, you can't alter them by bureaucratic regulation, but you can alter them, of course, by an amendment to the Constitution, and you can interpret what they mean. We're going to get back to that in a second. First of all, the first court case regarding civil liberties you need to know is Barron v. Baltimore. And please note that there's a V period, not a versus and not a VS. This is how court cases are done. So the first name, Barron, of course, is the plaintiff. Baltimore is the defendant, the year 1833. Both of these two are known as litigants. So the Barron v. Baltimore says that the Bill of Rights only applies to the federal government. Only the federal government has to listen to it. But according to that precedent, we're then going to get a second precedent, Gitlow v. New York. Again, I want you to think plaintiff versus defendant, both are litigants. In 1925, this says the 14th Amendment's Due Process Clause section of the Constitution is a clause, means that the Bill of Rights also applies to the states. So based on Barron, the Bill of Rights applies to the federal government, and based on Gitlow, it applies to the states. Now I want to look at this just for a second. We're talking the 14th Amendment right here. The clause is, no state shall make or enforce any law which shall abridge the privileges or immunities of the United States, nor shall any state deprive any person of life, liberty, or property without, and here's the key part, due process of law. That is the 14th Amendment. The 5th Amendment says, nor be deprived of life, liberty, or property without due process of law. The wording was done exactly the same. Now I want you to think about something. The 14th Amendment, this one, of course, is going to come after the Civil War is over, and this one is going to, if you recall, the 13th Amendment freed all slaves. The 14th Amendment gave them citizenship. So this comes with respect to that, but it's now interpreted in a different vein in Gitlow versus New York. So back to this part, the next screen. Looking at parts of the Bill of Rights and understanding what they mean is known as the incorporation doctrine. And you can see that up there. In other words, you're incorporating meaning into the Bill of Rights. Now, that is all the different Bill of Rights. If you look at any in particular, it's known as selective incorporation, the belief that some have been interpreted by precedent by the Supreme Court. In other words, what do the Bill of Rights mean? And we're going to be doing a lot of that in the next few days. So when you look at each part or clause of each Bill of Right, it's selective incorporation. All of them being understood is the incorporation doctrine, and doctrine is a belief. Okay, now here's the big question. What is due process? Again, due process is the clause, not Santa, but this just due process clause is found in the 5th and the 14th Amendment. And what does it mean? Substantive due process and procedural due process. I want everyone to get up in front of the computer, and I want everyone to jump up and down like a bunny rabbit. Come on, out of your seat. Come on, come on, come on, come on. Up, 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 up. If I mandated the school board had said, mandated that all students who were watching videos at home of their slightly crazy teacher, if they were mandated to jump up and down in front of the computer, come on, I don't see you all jumping, that would be substantive due process. It's in the Fairfax County Code or regulation. And if the code furthermore says any student that doesn't jump up and down, I don't see all of you jumping, like bunny rabbits, will be fined an additional, well, we'll be fined $10, which will go to Coach or Dr. Holla's candy fund. That would be the procedure. We would have to follow the procedure. So if Mr. Tremaine doesn't follow the procedure, that's different from the substance. So the substance says jump up and down like a bunny rabbit. The procedure is actually the principal going out and collecting the money, which of course you should, to help my candy fund. So you can do two things. One, you can change the substance by going to Congress and getting the law changed, or in this case Fairfax County's code, or you can have Mr. Tremaine not follow the procedure. And so when we see due process in the 14th Amendment, and I'm going to go back to it, and the 5th Amendment, we are talking about, one, following the law, and two, whether or not you like the law. Sometimes you speed, the law says what speed you can go, but the cops don't always follow and stop you if you're 5 or 10 miles over. Procedural due process would be not giving you a ticket for 5 miles over. Substantive due process would be the law itself, how fast you can go. And of course, both can have an impact on you. So that's due process. That is procedural and substantive. That is the incorporation doctrine, selective incorporation, the 14th and the 15th Amendment. If you have any questions, you can email me, you can ask your friends, or we can talk about it in class. Hope you enjoyed this. Bye.